AIR म्हणून सुपरिचित असणारी आमची कंपनी गेल्या 1 शतकाहून अधिक काळ विधिविषयक नियतकालिकं आणि पुस्तक प्रकाशनाच्या क्षेत्रात अग्रगण्य राहिलेली आहे. आज मुंबई उच्च न्यायालयाचे सन्माननीय माजी न्यायमूर्ती श्री रवींद्र चव्हाण यांनी लिहिलेलं बिफोर असेंडिंग टू विक्रमादित्यास थ्रोन या पुस्तकाच्या प्रकाशनासाठी आपण इथे जमलेलो आहोत. माजी न्यायमूर्ती श्री रवींद्र चव्हाण लिखित बिफोर असेंडिंग टू विक्रमादित्यास थ्रोन या पुस्तकाचं प्रकाशन करावं अशी मी प्रमुख अतिथी सन्माननीय न्यायमूर्ती श्री भूषण गवई सर यांना विनंती करते. माननीय न्यायमूर्ती श्री भूषण गवई सर, प्रमुख अतिथी म्हणून तर मुंबई उच्च न्यायालयाचे सन्माननीय प्रशासकीय न्यायमूर्ती श्री नितीन सांबरे सर विशेष अतिथी म्हणून लाभले आहेत. तसंच सर्वोच्च न्यायालयाचे सन्माननीय माजी न्यायमूर्ती श्री विकास सिरपुरकर सर व माननीय ॲडव्होकेट कुमकुम सिरपुरकर मॅडम, मुंबई उच्च न्यायालयाचे पीठासीन सन्माननीय न्यायमूर्ती, मुंबई उच्च न्यायालयाचे सन्माननीय माजी न्यायमूर्ती, बार काउन्सिलचे सदस्य, मान्यवर वकील मंडळी, प्राध्यापक, विद्यार्थी, AIR परिवाराचे सदस्य आणि ऑनलाईन लॉ चर्चा या ऑनलाईन माध्यमातून जॉईन झालेल्या सगळ्यांचंच मी मनापासून स्वागत करते. असं मनोवेधक शीर्षक असणाऱ्या या पुस्तकाचा नक्की विषय तरी काय आहे, त्यामागची लेखकाची प्रेरणा काय आहे हे जाणून घ्यायला आपण नक्कीच उत्सुक असाल. पुस्तकाचे लेखक मुंबई उच्च न्यायालयाचे माजी न्यायमूर्ती श्री रवींद्र चव्हाण यांनी त्यांचं मनोगत व्यक्त करावं अशी मी त्यांना विनंती करते.
Honorable Shri Justice Gavai, Judge Supreme Court of India, and one who has his feet firmly on the ground and head above the clouds. Honorable Shri Justice Nitin Sambre, Senior Judge of Bombay High Court at Nagpur, and a judge with firm conviction in the cause of justice. Honorable Shri Justice Sirpurkar, former Judge of the Supreme Court of India, and Senior Advocate Mrs. Kumkum Sirpurkar, Honorable Sitting Judges of the High Court, former Judges of the High Court, three of my very old friends, more than 60 years, are present here, advocates, law teachers, and my dear friends. And of course, my first critic, fierce critic, my wife. When I went with my first draft of this book to Justice Sirpurkar, he said it's like a judgment, replete with citations, but without what the author wants to say. He said, this is no judgment, and therefore made me rewrite the whole book once again. But I thank him for this. What he conveyed was right. We have judges whose judgments are replete with case law, but nobody ever comes to know what the judge wanted to say. So therefore, I corrected myself and rewrote the whole book. The book attempts to equip aspirants to judgeship with the essentials to occupy a judicial office. It aims at a clarity of thought and expression, And yet, there are over 100 instances of inaccurate expressions that could have been replaced by better alternatives. Our editor, Dr. Rohini Mahurkar, did dutifully point out all those expressions which should have been changed. But I chose to let them be. To illustrate, the quote at the beginning of the first chapter when people say that court is temple of justice, there is a grave danger that we perceive ourselves as deities in those temples. After this quote, there is another sentence. True, but why not work hard to live up to the public image? The mistake here is twofold. First is about punctuation marks. The second is, after the quote, the name of the person to whom quote can be attributed should have been there. And the subsequent sentence, true, but why not work hard to live up to that public image, was my comment on the quote. So it should have come below Justice Chandrachud's name, CJI Justice Chandrachud's name. Well, the object of leaving these inaccuracies, I will not say mistakes, in the book is this, that please read the book carefully. At the end of the book, there is an appeal that says there are over 100 such inaccuracies in the book. Please point them out. And when you point them out, particularly students, young lawyers, they will be duly acknowledged. And in the next edition, along with the name of the person, we will print it and say that this correction has been made because of suggestion by this student. This is just to ensure that we read carefully. We read every comma, every full stop, every punctuation mark, and not just browse through a book like a novel, which my book, earlier book was a novel. I will not elaborate upon the book's contents. I leave it to the curious and not so curious readers to work it out. About the quote at the beginning of the first chapter, and my comment, I think I owe an explanation as to how could I say something after the chief of our family has said something. He has the last word, no? Yet I felt something, therefore I wrote it. Those who have been or who are judges know that, and also judiciary as such knows, it's a question of image. It's the image of judiciary that counts. People believe in judiciary because of the image of the judiciary which we have assiduously built up. Therefore, trying to live up to that image is our duty. In fact, when we imprison a person in his image, that person will not stray away from that image. He will say, no, people expect this from me, not that. Therefore, the person will normally conform to the image which has been built up. The Honorable Chief Justice did say that there is a grave danger that we perceive ourselves as deities in those temples. This again is a matter of perception. Many of us may be looking at stone deities in big temples as granting boons to us if we praise them, if we make big offerings to them. Then they are no different from human beings, no? Human beings also like to be praised. If they are praised, they give you what you want. My idea of God, or the way I have been brought up, is this, that God is not hungry for praise or offerings. He's hungry for righteous conduct. I'm sorry, I should not be saying he, maybe she. So the God expects us to imbibe qualities of godliness, justice, compassion, equanimity, and not the one who simply says tathastu to whatever you ask for. So therefore, this was the thought in my mind which made me write that one sentence after the court. I hope this does not amount to contempt of court. Though I really don't care. A brother from Madras High Court with whom I had shared a draft of this book wrote to me to say that he jokingly suggested that I have a lot of work to do now. I have to write 2 more sequels, and consequently a lot of work for Shri Sumant Chitale of All India Reporter. We have to publish 2 more sequels. First is, this is before ascending to Vikramaditya's throne. The second would be after ascending to that throne. And third would be after descending from that throne. The first ought to be replete, that is the suggestion. Justice Lakshmi Narayan said that first ought to be replete with fox passes by people on the bench. And the second about autobiographical justifications of the unjustifiable. He said I should have no fear of competition because already I have thrown to the wind the caution, priyam bruyat, satyam bruyat, priyam bruyat. But I have already thrown that caution to the wind. He said, apriyasya cha satyasya vakta shrota cha durgabha. Hope this applies only to vakta and shrota and not to author and reader. So, shrotas may be durgab, but readers hopefully may not be durgab. I am extremely grateful to Honorable Shri Justice Gavai and Justice Nitin Sambre for having agreed to release this book, possibly for the sake of love for me. I thank all of you for being here today. Again, possibly because you like the theme or you feel that I don't necessarily utter nonsense. So therefore, thank you all. Thank you, Justice Sirpurkar, for first setting me on the right track. And of course, thanks to my son, daughter-in-law, and most importantly, my wife, who has graciously agreed to remain present in this function. Thank you.
धन्यवाद सर. आजचे विशेष अतिथी मुंबई उच्च न्यायालयाचे सन्माननीय न्यायमूर्ती श्री नितीन सांबरे सर यांना मी भाषणासाठी आमंत्रित करते.
Chief guest of today's function, Honorable Justice Gavai, and Guru to all of us, all judges who are present here. Honorable Justice Chavan, former judge of this court, Bombay High Court. Honorable brother and sister judges, dignitaries of the dais. Justice Chavan just now referred to that Gavai sir and me, we accepted his invitation. So this reminds me, his call, when I received his call, he said, कुठे आहे रे 29ला? म्हटलं सर दिवाळी आहे नागपुरातच आहे. हां कार्यक्रमाला याच. This is in lighter vein, but the positive side of it is, sir, you still remain our guru and you are every authority to direct mandate us that if we are wrong, it's every right you have, it is vested in you to correct us and to criticize us. Now, as far as the release of this book is concerned, last Wednesday, we had a get-together of sitting and former judges of the Bombay High Court. And of course, I invited sir. On that day, sir gave me a copy and said, की हे वाचून घे आणि मग बोलशील. त्याचा मागचा हेतू मला नंतर कळला की ॲडमिनिस्ट्रेटिव्ह जज म्हणून तुम्हाला ज्युडिशियल कामातून वेळ काढून जे ॲडमिनिस्ट्रेटिव्ह काम करतात त्याच्यातून पुढे वेळ काढा आणि पुस्तक वाचा आणि त्याबद्दल काही बोला व्यवस्थित. असो, I have read a part of this book, and this book narrates his journey as a judge. That is the day how he resigned from the Reserve Bank of India and joined as a judicial magistrate first class in the state judiciary. Later on, his promotion as a civil judge senior division, and thereafter within 2 years he became district and session judge, and then thereafter was elevated to the High Court. Now, before his elevation to the High Court, he had a lot of, I would say, a practical or rather an experienced and the knowledge that he gained out of his interaction with the various legal stalwarts. To name a few, one which is narrated in the book is Justice Daud, whom perhaps he has treated at the relevant time as his guru. A judge with very strong convictions. I know it because he was very close friend of my father. I still remember how his approach was, Justice Daud's approach. I must mention this incident. A very senior lawyer was arguing a matter for the then registrar of the university, Nagpur University, with a prayer for extension post-retirement. He wanted an extension on the same post. The last argument the senior lawyer made was, heavens are not going to fall if my client is granted extension by the government or the governor. Quick was the response from Justice Daud, even otherwise it's not going to fall if the extension is not granted. Sometime back I wondered that we undertake process, our High Court undertake process of selection of judges. And the selection team consists of 4 to 5 members. Sister Bharti is also one of the members of that selection committee. Some of the aspects which are evaluated by the committee during that small interaction or interview, I would say, is his acumen and his approach with the subject or the law field. I was wondering why not to have the assessment, why the institution or the High Court don't go for the mental assessment of that candidate as to whether there is a degree of decisiveness in this person or not. And then I thought that I am too junior to question this to my chief. While reading this book, I got the answer. It was initiated way back with his initiative, his assistance, and Justice Chandrachud was also involved in that issue. The topmost I am firm was taken assistance of And when the ball went into the court of Chief Justice, he said, all right, keep that file aside, that we'll consider later, and the file is still kept aside. The point is, we don't evaluate the candidate whether there is a degree of decisiveness in him or not. I am not saying or I am not doubting the decisions of the selection committee, but I am suggesting as to how his journey, how his approach was with the betterment, with the improvement of the judicial institution. I recollect, after reading few chapters from this book, that a judge, based on whatever record is provided to him, maybe pleadings, maybe evidence, and the assistance from the lawyer in support of the case of his client or litigant, whatever it is, he assessed from that record whether the person, what relief he is entitled from the court in a criminal case, acquittal, conviction, in civil case, whether the suit to be declared or whatever it is. But the book further reminds a judge of his duty that he is also being judged by the others who are the stakeholders in that case. It further narrates it out of the long experience of perhaps more than 50 years of Justice Chavan as to what is expected of a judge, what quality he should possess, and the mode and manner in which he should conduct while dealing with the matters. For example, the lawyers and judges, we are to some extent aware about the Latin words, maxims. But for a common man, if you use these Latin words, it's little difficult. Even for doctors, it's difficult to understand these Latin words or maxims. Then he narrates, Mr. Chavan further narrates, that it is for each and every judge in his life while working as a judge, requires to assess the medical evidence based on the medical terminology used in the documents or the evidence provided by such experts. He says, unless you understand these phraseologies, these words, what is the meaning of these words, what are the repercussions of these words on the merits of the trial, don't form an opinion, don't judge the case till then, unless you have understood the case into its entirety. Now, towards conclusion, I must say, this is, I would suggest, a complete guide for a person or a candidate who intend to become a judge in his life in the court of law. Sir, few suggestions I would like to make at this stage. Our Vice Chancellor is here. Our Director of Judicial Academy, Mr. Agrawal, is also here. Let this book be provided to all the law schools, not only national law schools, I would suggest all the law schools, so also the judicial academies, so that the judge, while adorning such position, should get to know these 50 years of experience, what does it mean in his life. I thank the AR family, so also Justice Chavan for inviting me for this function. All of you wish you a happy Diwali. Thank you so much.
धन्यवाद सांबरे सर. कार्यक्रमाचे प्रमुख अतिथी सर्वोच्च न्यायालयाचे सन्माननीय न्यायमूर्ती श्री भूषण गवई सर यांनी या सभेला संबोधित करावं अशी मी त्यांना विनंती करते.
The guest of honor, today's function, my esteemed colleague, the Administrative Judge of the Nagpur bench of Bombay High Court, Justice Sambre, the author and a person with whom I have a long association in various spheres, Hon'ble Justice R.C. Chavan, the publishers of the book and the institution which has done a pioneering work in India in legal journalism, the All India Reporter. Respected Vallubhau, Kumkum Didi, Kiran Vaini, my esteemed colleagues, past and present, Justice V.M. Deshpande, Justice Bharti Gangre, Justice Anil Kilor, Justice Sanab, Justice Borkar, Justice Prabhul Kubarkar, Justice Rohit Joshi, Justice Nivedita Mehta, my senior colleagues, Justice Rohi, Justice Kukde, Justice Zoting, the Vice Chancellor of the National Law University, Dr. Vijendra Kumar, the Registrar Vivek Ghane, the members of the Bar Council of India, Shri Ashish Deshmukh, the past member as well as the past President of Bar Council of Maharashtra, Shri Gavai ji, past President of Bar Council of Maharashtra, Parijat Pandey, Anil Gaur Dupe, the Director of the Maharashtra Judicial States Academy, Shri Girish Agrawal, the Principal District Judge of Osmanabad, Shri Swapnil Khati. We see the esteemed senior counsels, Shri Mishra ji, Mohan Sudhame, Shri Anjan De, the President of the District Bar Association, Shri Rohan Bagde, past President Kamal Satuja, the President of the High Court Bar Association, Atul Pandey, Secretary Jaltare, the senior members present here, and friends. I was in dilemma as to whether I should speak in Marathi or English, because Harsha started her campaigning in Marathi, but the speeches of Justice Chavan and Justice Sambre were in English. I think I will have to go by majority, but still I would like to speak in my own language, because I am always comfortable to be in Marathi. Though nowadays when I am out of Maharashtra, I have to speak in English. I have a long association with Justice Chavan. The first interaction with him was on 14th of November 2003. I, along with my colleagues, were sworn as the judges of the High Court, and he happened to be the first Registrar General of the Bombay High Court who read our warrants. Thereafter, within a short period, he was elevated, and he also happened to be posted at Nagpur, and our bond grew. We became closer to each other. He had always an academic bent. After his retirement as a judge of the High Court, he adorned the office of the President of the Consumer Commission for the state of Maharashtra, and he happened to live in Sarang, in 10 Sarang, which was a flat where I spent my childhood, because my father used to occupy that flat as a chairman, deputy chairman of the Vidhan Parishad. Thereafter, I also shifted to Bombay, and I was also in the Sarang, so we were in the same building. And since I had my sentiments for the flat, I used to go quite often to his place. After retirement, when it was decided to establish a National Law University at Nagpur, the pioneer is, of course, amongst us, Justice Resporter, Justice Resporter, Justice Bobde, Justice Chavan, myself and our other colleagues. Mr. Sakarkar is also there, the first registrar of the university. The Vice Chancellor, we were working tirelessly for the establishment of the university. And I recollect that in one entire summer vacation, we had spent on preparing the plans for the campus of the National Law University. We used to have meetings with all the experts right from 10 in the morning till 7, 8 in the evening. And that is how the buildings, the entire layout of the campus was conceptualized. His role in the establishment of the National Law University in seeing in its today's shape is remarkable. We'll always be indebted to him and Justice Shri for their human services. Subsequently, he had some issues because he has always the habit of having some issues with someone. On principles, and then one fine day he got disassociated himself with the National Law University, Nagpur, but still now I think he has given a second thought and is now contributing to the National Law University along with our other colleagues, Justice Vikramaditya, Justice R.K. Deshpande. Justice Chavan has always had an honest desire for the betterment of the institution. He was always full with ideas as to how the process of the appointment of the judicial officers should be improved, as to how the training that is to be imparted to him should be improved, as to how we should shape them as a perfect judicial officers so that in the courts you don't get result, but you get justice. And this always motivated him to be away from the mainstream and find out newer and newer ideas. And at times it was not liked by the powers that be, and therefore he used to have many differences. After my elevation to the Supreme Court, again we had an opportunity to work together. He was brought to Delhi by Justice Bombay as the Vice Chairman of the E-Committee, and he could play an important role in digitalizing, in moderning, in providing modern techniques to the Indian judicial system throughout the country. And I must, at this occasion, record my appreciation for the services rendered by him as the Vice Chairman of the E-Committee. This is I think the 5th book in the series. His first 2 books were basically the compilation of his speeches, which in his long career had delivered Cries in the Wilderness, and again more Cries in the Wilderness. And last book is Who Killed the Rule of Law? In fact, he wanted me to write a preface for that. But then, when our registry went through the book, and they advised me that, sir, it is better that you don't subscribe to. So, in any case, in the morning itself, I told him it would have been better that he had invited me to release this book after 24th of November, 1925, so that I could have spoken more freely. Anyway, the book, as all of us know, reflects the hard work and the dedication and the devotion which Justice Chavan has put in his long journey of almost half a century in various offices. The book starts with the anecdote of Raja Bhoj and Vikramaditya. You must have all read that. Raja Bhoj considered himself to be a very good king, but his court halls were empty. So he thought that either the entire situation in the state is very good or there is something else. Then he was told by someone that there is a Guraki on the hills and all the villagers, the people residing in the state go to him for justice and he imparts justice there. Out with the situation, he directs the excavation of the mountain and he finds the throne of Vikramaditya and he brings it to his palace. When he decides to start, when he decides that now he will start imparting justice, the throne has 32 statuettes and one of them comes to life and says that unless you consider yourself to be as pious and as just and as virtuous as Vikramaditya, you cannot impart justice from this throne. So it took 32 days to understand as to how Vikramaditya used to impart justice and thereafter starts imparting justice from that throne. As I always say, judging is not easy. Judging is, त्याला मराठीत आपण म्हणतो सतीचं वाण आहे आणि ते निभवणं सुद्धा फार कठीण असतं. And he gives a clear admission in the book that when he became a judge at the age of 23, he did not know anything. And one senior lawyer, Mr. K.D. Deshpande, told him that, what is your age? And he said, 24. He said, Mr. Deshpande said, I have put in double of your age as a lawyer. And then Justice Chavan decides to learn from him. And Justice Sambre has already referred to Justice Daud, who was his district judge. And so on, and so on. And therefore, finding out the lacunas in the judicial system, the lacunas in the appointment, the lacunas in the training, over the years, he has brought his experience, rich experience, into this book so as to suggest improvements in the judicial system of appointments, in the system of imparting of justice, and the continuous legal education. I'm happy because the bar councillors are here and bar councillors are continuously implementing the continuous legalization program throughout the Maharashtra and which is now also started to be emulated in the other parts of the country. The book authored by Justice Chavan stands as a significant contribution to the discourse on judicial conduct, offering both practical advice and philosophical insights for judges as well as legal professionals alike. Justice Chavan's deep understanding of the judicial role, combined with his thoughtful analysis of relevant literature and legal precedents, makes this book as an indispensable resource for anyone dedicated to the pursuit of justice. Justice Chavan has described the role of a judge as both observer and recorder in fundamental yet fraught with challenges. He had given the suggestions as to how the judge should record the evidence. He should not be a mere spectator, but he should observe the demeanor, the conduct of the witness to find out the truthfulness in the testimony given by him. The book also dwells into a crucial aspect of judicial responsibility, the need for precision and clarity in the recording of evidence and observations. Justice Chavan weaves in a single thread legal theory, literature, and real-world examples, offering a nuanced analysis of judicial decision-making. The author's reflection on the foundational training of judges is both instructive and profound. Justice Chavan recalls his own early lessons, which emphasize the necessity for a judge to be keenly observant, attentive to every detail within the courtrooms, and to avoid the pitfalls of passivity. Justice Chavan's reflections on his own experiences underscores the critical role of practical training in the judiciary. Through vivid anecdotes, the author illustrates how academic achievements alone are insufficient to prepare one of the profound responsibilities of the judicial role. In one of the chapters, he refers to the present-day scenario. Earlier, the senior lawyers used to train their junior lawyers, but he shares that nowadays that practice is diminishing. When we are on this issue, we also need to reflect as to whether, like Justice Chavan has given his anecdote, when we passed out from the law school, 3 years practice, and I joined the chambers of my senior at Mumbai, I took around 6 months to realize that I had learned nothing in the law schools, and my training had started only after I became a judge. So as to whether the practice of permitting fresh graduates to appear for the judicial magistrate first class examination also needs to be introspected. By critically examining the judicial recruitment process, Justice Chavan identifies key flaws that undermine the selection of candidates truly equipped to administer justice, highlighting the gap between theoretical knowledge and the essential attributes of patience, understanding, and a deep sense of fairness. Justice Chavan's insights are complemented by a fascinating reference to Lord Denning's recounting of a judge who, despite his well-meaning intentions, oversteps his bounds by excessively questioning witnesses and counsels. The case detailed in the Due Process of Law serves as a poignant reminder of the perils of judicial overreach and the importance of adhering to the role of neutral adjudicator. The judges are also supposed to listen to the lawyers. No doubt that in Supreme Court on Mondays and Fridays, we cannot afford to endlessly listen to the arguments. But that doesn't mean that the lawyers should not be given an opportunity of being heard at all. I remember of one anecdote when I was sitting at Nagpur in a full bench with Justice R.K. Deshpande as my third judge. I was the second judge, and the bench was led by a senior judge. The learned judge put up the case for almost 30 minutes and asked the lawyer, is it all that you have to say? The lawyer said, my lord, I have yet to begin my argument. So judges are basically to first listen and decide. Justice Chavan astutely analyzes how literature intertwines with reasoning, exemplified by the case of Liversidge and Anderson. Lord Atkin's dissent in the House of Lords draws on Lewis Carroll's Alice in Wonderland to critique ambiguous and legal interpretations. Through this literary reference, Justice Chavan highlights Lord Atkin's emphasis on clarity and precision in legal language, advocating for a straightforward approach to interpreting statute. We are not short of cases wherein after reading the judgment, even with an experience of total more than 40 years at the bar and at the bench, it is difficult to understand as to what the judge tries to tell us through the judgment. And another anecdote, again from Nagpur. One of the learned judges, we were lawyers at that time, when his orders used to be passed, we were required to ask him whether the bail is granted or refused. The learned judge used to say, I have done my duty by passing the order. It is for the office to interpret it. I think Justice Resporter was also a lawyer that time, and he must have also faced those difficulties. The book is a significant contribution to the discourse on judicial conduct, fact-finding, and essential qualities of a good judge. It serves as a guiding light for anyone dedicated to the pursuit of justice, reminding us that the true measures of a judge lies in their continuous pursuit of fairness, wisdom, and integrity. Justice Chavan provides a thoughtful analysis of the preparatory steps a judge should take before commencing a trial. They emphasize the importance of thoroughly reviewing the case record, identifying facts or documents that are admitted to or do not require further proof, and reassessing the issues framed in civil suits. Justice Chavan advocates that the proactive approach can prevent potential setbacks, such as the need to recast issues during the trial, which, though legally permissible, might reopen proceedings and cause delays. The record of the trial court is very important because it is the record on the basis of which the matters are to be heard by the Superior Court, the District Court, the High Court, and the Supreme Court. I had learned one thing from Justice V.M. Deshpande when we were sitting together. I used to read the English version of the witnesses when we were deciding criminal appeals. But he said, no, we must read the original Marathi version so that we know what is the... So it's a process of learning. You go on learning till the end. After I came to the Supreme Court, I had to learn the IBC. For the first time, I came across that such a code exists. But I was fortunate that sitting with Justice Nariman for an year, I got an opportunity to learn that law, and I could now author many judgments on that issue, which, in my view, are understood by a common litigants. I always believe that the judgments are written for the litigants and not only for the lawyers. If a litigant is required to engage the services of a lawyer to understand as to what is written in the judgment, then according to me, that a failure of a judge in not properly writing a judgment. Justice Chavan explains that issues in a case function like a conditional judgment, determining outcomes based on whether the plaintiff or defendant proves specific facts. They argue that a judge should not proceed to trial without revisiting the issues, even if initially framed by a predecessor or themselves some time ago. As new admissions and complexities may arise, by organizing the issues in a logical order before trial, a judge can avoid the awkwardness of addressing them out of sequence or deeming some issues redundant while drafting the final judgment. This careful preparation ensures a more streamlined and effective trial process. Justice Chavan insightfully explores the importance of an open mind in judicial reasoning, emphasizing that a judge should avoid confining their thinking to their personal experiences and understandings of life. Instead, they should remain receptive to new perspectives, ways of lives, and varied human interactions. Justice Chavan illustrates this concept using an example from Jerome Frank, which underscores how judges can reach different conclusions from the set of facts due to their diverse experiences. He devotes a chapter as to how your childhood learnings would help you in your further journey as a lawyer and also as a judge. A judge's role extends beyond finding the right answers. It involves ensuring those answers are grounded in a profound sense of justice. By integrating legal acumen with moral insight, judges can navigate the complex interplay between law and justice, upholding both the letter and the spirit of the law. The author deepens the analysis by referencing philosophical insights, including Professor Michael Sandel's reflections on justice and Professor Amartya Sen's distinction between Niti and Nyay. These reflections challenge readers to consider the broader implications of judicial decisions. The innovative concept of a digital twin in judicial decision making, introduced by Professor Dr. Dubey, showcases a forward-thinking approach that underscores the importance of evolving judicial methods to better serve the cause of justice. Justice Chavan insightfully examines the critical role of judgment writing in the judicial process, drawing on Henry Weppen's reflections in legal writing style. The act of writing ensures that the reasoning is thoroughly examined, helping to identify any missing links in the chain of logic that might not have been apparent during the trial decision-making process. Nowadays, we come across the judgments which run into 500 pages, 600 pages. The question is, how many of us read them? The litigants, not the lawyers, are interested in rhetorics. They are only interested in what is the proposition of law that the judgment lays down. And therefore, I think it's high time that we should reflect upon writing unnecessarily lengthy judgments. Apart from making it difficult to understand to the lawyers and the litigants, they also unnecessarily encroach upon the precious judicial time, which they could have utilized for deciding many other matters. Justice Chavan emphasizes that every judgment has three distinct audiences, each with unique expectations. For the parties, the judgment must be clear with reasons expressed in simple language, providing a smooth, logical explanation of the decisions. It should guide the reader effortlessly to the conclusion, like a child sliding down a slide. For the appellate court, the focus is on legal accuracy and the adherence to the law. This analysis highlights the multifaceted nature of judgment writing, balancing clarity, logic, and legal precision. I'm aware that many of you must be aware about a learned judge who was initially in the Himachal Pradesh and now in Punjab and Haryana High Court. Even after reading the entire judgment, it is not possible for, at least it has not been possible for me for the last 5.5 years to understand what is been written by the learned judge. If this is so, then the very concept of a judicial review of that judgment is hampered. As Lord Coke, which has been again quoted by Lord Denning in The Due Process of Law, brevity becometh the gravity of this profession. Law takes little delight from varnish of words and garnish of flowers. I'm sure that these painstaking efforts which Justice Chavan has made in authoring before ascending to the Vikramaditya's throne will not only be a beacon for the judges when they enter judiciary, but will also be a material which will be useful for the lawyers in their initial days of practice and making them suitable to adorn the Vikramaditya's throne, which is replete with justness, piousness, and virtuousness. I express my gratefulness to Justice Chavan for coming out with this book, He has said that there are 2 more in pipeline. I do wish that they will be unveiled only after 25th of November, 24th of November 2025, so that I can speak more freely. I take this opportunity to congratulate my 3 new colleagues who have just 3 days recently joined the bench. All of them are from Nagpur. Justice Nivedita Mehta, Justice Praful Kubadkar, and Justice Rohit Joshi. I, on behalf of all of us, extend our congratulations to all 3 of you and wish you will be successful in your career. I had invited them for breakfast today morning, so they were seeking some guidance. I think I will only request Justice Chavan to give this copies of this book to 3 of them, so that they get ready material. After 5 years, there have been elevation to the Nagpur. The last were Justice Garote and Justice Kilor. We are happy that we have got 3 more, and I will assure you that in the next year you will have many more. Thank you very much to All India Reporter for the noble work. I have always been associated with the many events organized by All India Reporter. I have inaugurated the e-cafes at various places in the various high courts. They are also a part of the Judicial Academy being constructed by the Maharashtra and Goa Bar Council at New Mumbai. I'm grateful to them for publishing this book. I am also grateful for giving us this gift, as suggested by Justice Sambre. Will be donating these gifts on your behalf to the Maharashtra Law University Nagpur, which will be awarded to the meritorious students by the university. Once again, I thank you very much. Thank you very much.
धन्यवाद न्यायमूर्ती गवई सर. मी ॲडव्होकेट श्री ऋषिकेश चव्हाण यांना विनंती करते की ते आभार प्रदर्शनासाठी यावे.
Ladies and gentlemen, a very good morning to one and all present here, as well as who have joined us virtually through YouTube. Today, we are blessed to have a dais comprising of excellence in field of law, including 3 stalwarts who hold torch of judiciary with grit and honor. And I find myself fortunate to have witnessed their exuberance today. The chief guest for today's function is a luminary whose decisions reflect comity while being within the framework of law, and who is guiding light of wisdom for most in the legal fraternity. I thank Hon'ble Justice Gavai for acceding to our request and releasing the book with his gracious hands. Our guest of honor today was a sportsman, a students activist, a versatile lawyer before becoming an astute judge who is known for his reasonableness and for motivating junior lawyers always. I thank Hon'ble Justice Sambre for gracing this occasion by his presence. The third stalwart is someone I know very closely and who was a judge for almost half of his life, and if I may say, is an eternal servant of judiciary. A bookworm by birth, a writer by habit, and a speaker by choice. His mind never rests, and I thank him for conceiving this 5th book that was released today. Publishing is a medium that enables sharing information and spread the knowledge. All India Reporter is known for its neat, accurate, and deft publishing. I thank the man behind this business, Shri Sumant Chitale, and also entire team of All India Reporter for this publication and hosting this function. I take this opportunity to thank Hon'ble Justice Sirpurkar and Senior Advocate Mrs. Sirpurkar for their presence. I thank the Honorable Sitting Judges and retired judges of the Bombay High Court. I thank the judicial officers present and also retired to have graced this occasion by their presence. I also thank the president of bar associations, the bar councillors, the professors, and all the teachers and students who have present today. I would like to thank the representatives of our fourth organ, the press and the media, for covering this function. I would be failing in my duty if I do not thank Mr. Makaran Joshi, one of the finest artists, who is the creative brain behind the cover of the book and who has artistically manifested the ideas of my father, that is the author, into covers of all the books which he has written. I thank all the advocates, friends, and family members who are present today. I thank all the viewers who joined us virtually through Law Charcha on YouTube. Thank you very much. Wish you all happy Diwali and a prosperous new year. And with the permission of our chief guest, I declare that this event is successfully complete. Thank you very much.